The rule of reason. In the section of the Sherman Act that prohibits combination or conspiracy, the statutory language is broad and vague. So in 1911, the Supreme Court recognized, in the case of United States versus American Tobacco Co., 221 U.S. 106, that the Sherman Act could not be intended to prohibit all combinations. Some combinations are entirely unproblematic. Instead of making them per se illegal, courts apply the so-called rule of reason in antitrust cases where the economics of certain practices is not immediately obvious. Rule of reason requires a great deal of fact-finding. Typically, there'll be expert testimony from PhD economists who must define the relevant market and show substantial likelihood of harm in the marketplace. The market definition exercise is not necessarily straightforward. However, once the market is defined to the satisfaction of the fact finder of the court, the prosecution must still prove that the practice tends to restrict competition, which usually includes showing that the business has market power, defined as the ability to raise prices above those that would be charged in a competitive marketplace. The plaintiff must show that the defendant's activities injured competition, not competitors, but competition itself. This is a high bar, and its height might explain why the FTC has more recently attempted to stop mergers through its internal administrative judicial system instead of suing in U.S. courts under antitrust law. Under traditional rule of reason analysis, the plaintiff bears an initial burden of showing that the alleged combination or agreement produced adverse, anti-competitive effects within the relevant product and geographic market. The plaintiff can satisfy this lofty burden by proving the existence of actual anti-competitive effects, such as reduction of output or increase in price or deterioration in quality or services of goods or services. If a plaintiff meets this initial burden of adducing adequate evidence of market power or actual anti-competitive effects, the burden shifts to the defendant, who can show that there are synergies, that there is a sufficiently pro-competitive objective. These synergies are advantages resulting from the combination that would tend to increase net social welfare. For example, when evaluating the Whole Foods acquisition of competitor Wild Oats, the FTC argued these two companies were the only two major companies who operated, quote, premium, natural, organic superstores. The parties, conversely, argued there is no such thing as a PNOS market. Rather, many stores sell organic goods, and the market for supermarkets and grocery stores is huge, such that their merger would have little to no effect on things like prices for organic milk. The FTC failed to carry its burden because it failed to show there was a market for PNOS in particular. Now, after the FTC lost the case, the FTC found documents in which the CEO of Whole Foods called the merger Operation Goldmine, in which he expressly stated his intent to purchase Wild Oats, not for its synergies, but so he could close down competitors and jack up prices. After this discovery, the FTC sought to undo the merger on the basis that it constituted a per se violation. After much discussion about the impossibility of, quote, unscrambling the eggs, meaning unmerging already merged firms, the FTC found itself unable to proceed. In that case, the FTC ended up with egg on its face.